Get ready to take a flamethrower to the official narrative and learn what the elites don't want you to know. You're listening to The Tom Woods Show.
Hey everybody, welcome back to The Tom Woods Show. It's episode 2525 with our old friend Michael Boldin. This is his first time on the video version of The Tom Woods Show. Michael was guest number 1 on The Tom Woods Show all those years ago, 11 years ago. And here he is again. Of course, he is the founder and executive director of the 10th Amendment Center, which has had an influence vastly disproportionate to its relatively small size. And we've got an interesting discussion ahead of us today, but I am delighted to welcome old Michael Boldin back.
I am so happy to be here. I know some people think first means best. It was just the trial run because we're such old friends. I'm really grateful to be a part of the show today, Tom. Thank you.
It was the pilot, you know?
Yeah, of course.
It was to see if it would work.
You go with the people you trust.
Yes, that's right. And if the pilot stinks, then there's no show.
Exactly. Well, we got lucky on that one.
We got lucky. Oh my gosh. Anyway, I got some stories. There's some funny stories about that first episode, but let's stay focused on this. Speaking of funny stories, you came on one of my cruises that I did with Bob Murphy in the past.
That was awesome.
And so I want to remind people, I'm doing another cruise, TomWoodsCruise.com. It is the most fun. Can you attest to that? It's the most fun you can possibly imagine?
This is the most fun you can possibly imagine. And that is an understatement. I literally left that thing on such a high, made so many new friends that I stay in touch with today. I mean, this has been years. It's really like amazing, especially for someone who lives in Southern California, like yours truly here. You know, it's hard, the people that, have ideological similarities are kind of far apart. I mean, there's a lot of us here, but it's hard to get to each other. So to have everyone concentrated onto a ship, trapped on a ship for a week with people who love liberty, that's pretty awesome. And everyone's really fun. And it's like you guys do games. We talk philosophy. It was just a great time.
And I'm doing a murder mystery party with this huge group. We have so many fun things planned. I actually have to tell you some of the things I have in mind that I haven't told the folks, but ton of fun, so check it out, TomWoodsCruise.com. What we're talking about today is August 1st, or at least the release day. The day this is coming out is August 1st. Now, August 1st happens to be my birthday. Can I tell people when your birthday is?
Absolutely.
Okay, Boldin's birthday is December 1st. So I'm 4 months older than he is. And so
4 months wiser.
4 months wiser. You'll see. I'm sure it'll come through.
Only 4 months.
One of these days. But a couple of years ago, my friends played this joke on me, where on December 1st, do you remember this? They were sending me birthday wishes. And so the first couple came in and I said, oh, no, you made some mistake. It's not my birthday. It was no mistake. They were just screwing with me. They had convinced all of Twitter and Facebook that it was my birthday. They even changed my Wikipedia entry to have my birthday be December 1st, 1972. So, in fact, my wife even made me a birthday cake that day.
That was
like she was
awesome.
in on it with these people.
And you're thinking, look, I just went through this whole birthday shenanigans just a couple of months ago. I don't have to do this again.
Yeah, well, like I was saying to Dave Smith, look, don't you remember? You just wished me a happy birthday. Doesn't this seem a little bit soon? Anyway, all right. So
we got a doozy today to talk about. This is a doozy.
Well, the reason I mentioned that it's August 1st is not simply because it's my birthday, but because this is the day that the Law and Liberty blog is releasing a symposium on the subject of nullification, state nullification of unconstitutional federal laws. And there's an article that apparently several of us responded to. I've seen only my own response so far. And so basically the way it happened was Mark Pulliam wrote this article. Mark's been on the show before, and I've been perfectly friendly with him. He's a retired lawyer, and he wrote this article arguing that state nullification has no constitutional basis, and it's chaotic, and there needs to be a final arbiter, and kind of the usual arguments. And so I was approached by the Law and Liberty blog. Would you write a response to this? So certainly I did. And then I sent the article and my response to old Michael Boldin here. I said, like, what do you think about this?
Oh, man.
I said, maybe we should make a Tom Woods Show episode on it because you haven't been on the Tom Woods Show in so long. I love what the 10th Amendment Center is doing. And this kind of thing is just the kind of thing that you and I could geek out on this, but we actually have an audience of people who would enjoy hearing the geeking out. We should do it and record it.
Yeah.
So
let's make it happen.
So I'll have a link to the whole thing in the description and also at tomwoods.com/2525 if you'd like to follow along with us or read the symposium at your leisure. But Michael, let's start off. I mean, basically, the arguments more or less boil down to that we are, those of us who support this idea, are selective in the historical episodes that we point to, that we minimize or diminish the Supremacy Clause of the Constitution, that James Madison disagreed with us, that Thomas Jefferson may have agreed with us, but he was a dum-dum because he wasn't at the Constitutional Convention. So that doesn't matter as much.
Doesn't count.
So there's that. And then what else? Well, then also just a general argument that, look, this is not mainstream. Like, nobody's going to accept this. Certainly nobody in the legal system. And that even conservative legal voices don't accept it. So the Cato Institute or the Heritage Foundation or Randy Barnett or whatever it is. So I went through and more or less responded to all of these. And it's the first time in a long time, Michael, that I've first of all, I don't really write articles anymore. I write to my newsletter list, and people who want to hear from me, I write to them. But I haven't written a rebuttal article in so long, and I'd forgotten how exhilarating it can be, really. So,
man, that article made my head spin, though. So good on you for finding the silver lining and how, I mean, it is fun to be able to think about philosophical arguments. But good on you on that.
Well, thank you. And I had my 21-year-old daughter, Regina, was very anxious to read it, both the original article and my response. And she thought it was such a great smash. And the thing is, I'm not mean or rude in it at all.
Right.
I mean, I've had nothing but good relationship with Mark Pulliam. So I'm not going to be bellicose, although I felt like he was a little bellicose. In fact, Regina said, she said, I thought you handled this very diplomatically, given how nasty the original article was. And I said, that's funny because I've responded to so many articles like this that by comparison to those, this one was pretty tame, I thought. It wasn't.
Well, to be honest with you, there is probably no one on the face of the earth more involved on a day-to-day basis in nullification movement efforts than your good friend, Michael Boldin. So I've seen plenty of these articles attacking it over my last 18 years. And to be honest with you, if I didn't know where it came from, I would have said, oh, wow, that's Rachel Maddow doing another 14-minute segment on our 10th Amendment Center and Nullification, what she titled Confederates in the Attic. It didn't have many different points. Of course, some of the rhetoric, the hyperbole in there on the Rachel side was far more aggressive. So I was kind of surprised, a little disappointed in the way that Mark approached this, because I would consider many of his goals as very friendly to the same types of goals that you and I would have, Tom. And in fact, I think his writing on other topics has been fantastic.
Yeah. So, all right, let's go into some detail for people who haven't read it. Let's make this a standalone conversation.
Yeah.
And I will start by saying, by the way, that I am completely unmoved by the argument that even other people right of center don't agree with this. Well, let me take a wild guess. They all went to law school, right? And in law school, they are basically taught constitutional law. And our friend Kevin Gutzman, who has a law degree, but he also has a PhD in history, reminds us that you should never confuse constitutional law with the Constitution. Constitutional law is is learning a series of cases, basically. You learn a series of cases.
Nothing happened before 1803.
Right, exactly. And the law school is where even the right-of-center law student has his brain colonized by the nationalist theory of the Union, where the United States is and has always been a single, indivisible whole, an undifferentiated aggregate of individuals, and there is a single, indivisible, infallible, unbreakable power center that of right rules over it all. I mean, they're taught to believe all that because that's what the cases seem to imply. But, Madison said, you learn what the Constitution means by going to the state ratifying conventions. Well, these people's hero is John Marshall, Chief Justice John Marshall. How many references in John Marshall's decisions are there to the state ratifying conventions? Literally zero. So this is not the end of the discussion. How about this? The law schools that just might be as corrupt as the universities in general. How about that? Is that
CNN.
Absolutely impossible?
Yeah.
So that doesn't move me. And likewise to say, oh, this is a very out of fashion idea. One of my replies was, every fashionable left-wing idea started off unfashionable and no one believed in it. And yet here we are living in the world they made. So, I'm about ready for some of my unfashionable ideas to sweep the boards. I think I'm due, Michael. I'm due.
I would also throw out there, if it's so unfashionable and so unpopular, why spill 3,700 words and 12 pages writing about how it's so dangerous and might bring an end to the Union? It's basically, the title was Nullification or the Constitution. So his argument is that, I see it as fear-mongering, basically warning conservatives to not do something, and this is important, that no one is doing. And almost no one is even trying to do, because somehow this thing that isn't happening is going to destroy the Constitution and the Union yourself. Longtime Tom Woods Show listeners are familiar with the white supremacy hoax episode of a few years ago, where we're supposed to be living in total fear of this rise of white supremacy that doesn't really exist. They're just using fear-mongering. Patrick Henry nailed it on this. He said, it is the fortune of a free people not to be intimidated by imaginary dangers.
Well, even if it were a danger, one of my replies is, well, then choose your fear. You can fear that if a state has the ability to declare a federal law unconstitutional and obstruct its enforcement, that this might tend toward pulling the Union apart. I suppose that's a fear. But the other fear is that you have an absolutely irresistible lawless regime that does anything it wants to, regardless of the Constitution. Right. Can't we at least acknowledge that that's another fear?
Absolutely.
And that people of goodwill can disagree about which fear should strike, more profound concern in us.
Yeah, my big issue, though, with what Mark had to say is what he's describing that everyone should be afraid of actually isn't happening. And in fact, one of the parts where he links to it as an example, he cites CNN, who literally makes things up about a new law that was just passed in Utah called the Constitutional Sovereignty Act, and cites CNN as an authority. I would just throw out there, people who cite CNN as an authority about what states can or cannot do under the Constitution, you should look at them a little from the side, maybe a little bit. I would be a little concerned about that. So I would like to actually, if you're interested, I'd like to focus on where he's basically misdirecting things and then find out all the ways that we actually agree, because he cites a number of things and examples of how states can push back or respond to federal acts that we see as bad policy or unconstitutional. He cites a number of ways that he says you can absolutely do this. And then he goes into this, how long article discussing a handful of situations where he says they're going beyond that line. And I would actually argue that in those situations, it's not happening either. So we're spending all this energy discussing something, Mark, that actually isn't even happening. I'm not sure if he's aware of this, but I'd be happy to clear that up.
But maybe he's saying that in that case, if what he's describing, which would be a state actively preventing the enforcement of an unconstitutional federal law, if that's not happening, then you shouldn't be calling what you're doing nullification.
Yeah, sure. We can call what we do, the Easter Bunny path. I don't care what anyone calls it. And in fact, one of the people that he cites, my friend Rob Nadelson, who I think was really a great inspiration. He worked with me very early on at the 10th Amendment Center, taught me a lot of things. He cites Rob Natelson, this article that he ran a few years ago that we republished called Struggling with Nullification. And he says he agrees with Mark on these various ways that states can push back, and says there are certain very narrow ways where they're not authorized to do that. And we could actually debate that if we'd like. But the ones where Mark and Natelson say you can't do, they're just not being done. And the ones that they can do, he specifically says, nullification used to be defined much more narrowly back in the day, but more broadly today, and specifically the 10th Amendment Center calls all these other acceptable things nullification. Just calling it that doesn't mean they're illegal or unconstitutional or wrong. And in fact, it's still okay to do it no matter what you call it. And I think that's really the big issue here.
Hey, everybody, you've heard the expression, be the change you want to see in the world. Well, that's exactly what Federated Computer is doing, because as you know, increasingly Google, Microsoft, Apple, Zoom, and the tech bros running big tech today think your private data is their playground for their advertising networks and AI systems. Well, one way you can avoid all those things is not using the quote-unquote free tools big tech wants you to use. And that's where Federated Computer, the market solution to all this, offers a full replacement for Google, Microsoft Office 365, Slack, Zoom, all the tools of big tech, but designed for people who care about privacy, don't want to be treated like cattle, and want a great price. Everything's encrypted end-to-end, fully backed up daily. We're talking about private email, group chat, file storage, WordPress, all the applications you need for your business or team, all bundled into one easy monthly subscription that's 10 times less expensive than big tech offerings. You get unlimited users, fantastic personal customer support from real human beings, and the assurance that your data is your data and not big tech's. Well, visit www.federated.computer for your free 30-day trial and use coupon code WOODS for 10% off your first 6 months. So how about that? A company that thinks its job is to provide you with services you're looking for at a great price rather than spying on you or shutting you up or manipulating you. So take your first step along with other Happy Woods listeners towards digital freedom. Visit www.federated.computer today for your free 30-day trial and use coupon code WOODS for 10% off your first 6 months. It takes a little time to criticize the way people like you and people like you and me, people like me, yes, correct, have talked about the Supremacy Clause of the Constitution.
Mm-hmm.
So saying that this Constitution and laws made in pursuance thereof shall be the supreme law of the land, that thing, that we are, we're basically diminishing that into nothingness in the way we interpret it. And that we need to bear that in mind, that the Constitution is the supreme law of the land. Okay, but what I do in my response is I dig out what Alexander Hamilton said. Now, Alexander Hamilton cannot be accused of wanting to minimize the force of the Constitution.
Right.
And he more than once said that the federal Constitution and federal laws will be supreme only to the extent that they are in pursuance of the Constitution.
Right.
And no farther than that. And there are multiple quotations. Brian McClanahan has done good work on this, upholding this interpretation. And so, it's funny, these clauses, like the necessary and proper clause, for example, when you look more closely at them, that they're supposed to authorize all this vast array of unspecified powers. When you look closely at them, even you can even find advocates of a fairly strong central government refuting these broad interpretations. So Hamilton said about the necessary and proper clause that the Constitution would be exactly the same if we didn't have that clause in it. Right. It would be exactly the same. That clause doesn't give it any extra power than it would have had otherwise. So my argument is it's not enough for Mark Pulliam to come along and say, now, wait a minute, I don't like that interpretation of the Supremacy Clause. Well, I'm real sorry to hear that you don't like it, but what's more important is whether it's right or wrong.
Let's cite Alexander Hamilton. More. Can I quote Hamilton from Federalist 33?
I wish you would.
Okay, Hamilton put it this way: it will not follow from this doctrine of supremacy, that acts of the large society which are not pursuant to its constitutional powers but which are invasions of the residuary authorities of the smaller societies, will become the supreme law of the land. These will be merely acts of usurpation and will deserve to be treated as such. And even people who tend to cite Hamilton on the Supremacy Clause in Federalist 33 skip that last part where he's saying this is an act of usurpation. We understand from the American Revolution that part of the principles of the Revolution was that acts against the Constitution are void, as James Otis Jr. put it back in 1761 against the writs of assistance. Well, how do you treat an act that is void, an act of usurpation, theft of power from the sovereign people of the several states? Well, you disregard it. And that's exactly what Hamilton was getting at there in Federalist 33. He took even more aggressive language back in Federalist 28. And in Federalist 16, he stumbled upon a really interesting truth that plays into the strategy that we use today. He was complaining about the Articles of Confederation, that it basically, specifically, if you think about the tax requisition system, the federal government or Congress had to go to the states and tell them, you guys owe this much money, and they couldn't do the collecting. The states had to do it, and Hamilton thought this was terrible. And so he said, if the interposition of the state legislatures be necessary to give effect to a measure of the Union, they have only not to act or act evasively, and the measure is defeated. So we recognize, as Hamilton did, that as long as the federal government relies on the actions of the states to implement or effectuate any of their acts or regulatory programs, all the states have to do is say, no thanks, we're not going to participate, and it'll bring them to an end. Now, we live under the largest government in history today, and as the National Governors Association put it in 2013, this was like, of course, supposed to be a bad thing, one of these fake shutdowns when they don't really shut anything down but a few parks or try to make things inconvenient for people. Well, the National Governors Association said states are partners with the federal government on most federal programs. Well, here's the dirty little secret that these people don't want us to know, is that partnerships don't work when half the team quits. Hamilton understood this in Federalist number 16. I can cite people like James Madison, Roger Sherman, and so many others who said this is the way to defeat federal programs, as long as they're relying on you, and they rely on the states constantly today. So we have a very effective approach. And in fact, Marx specifically uses some time in his article to say that this approach of saying we are not going to help the federal government on a state level is totally okay. He specifically said declarations of non-cooperation are permissible. He just says that doesn't count as nullification. So nullification is terrible. Even if everybody else calls this nullification, Jeff Sessions called it nullification when he was the Attorney General, just don't do nullification. So he's conflating, he claims that we're all conflating things. But the more popular use of the term nullification, and maybe it's our fault for doing this here at the 10th Amendment Center, calling it that, but what are we going to say? Refuse to comply now? No, we say nullify now, because the goal is to bring these things to an end.
Well, I'm still interested also in arguing this out on a theoretical level too.
Yeah, of course.
And so it's important to me to get this thing right about James Madison, because Madison in around 1830 started to say, look, all you people, back in 1798 when I wrote the Virginia resolutions, you all misunderstood me. I was not saying that the states could just could obstruct the enforcement of an unconstitutional law. I was saying that the states could, solemnly and formally protest unconstitutional laws. And so Mark cites that in all seriousness as, the end of the discussion. So I had to point out to him that Madison's flip-flopping on things like this was a source of partisan humor in his day, and that people found it implausible for him to say in 1830, all I meant was that the states could just protest unconstitutional laws. Well, what would be the point of writing? No one disputed that. Like, everybody knew the states could do that. Why would you bother writing resolutions about that? And then when you had the report of 1800, you had your chance to explain to people that you hadn't meant what they thought you meant, but you just doubled down on it. I mean, why are we supposed to believe you now? But none of this makes sense. It was, in fact, Albert Taylor Bledsoe said something along the lines of, Madison seemed more solicitous of maintaining the something like maintaining the solidity of the Union than of his own thoughts, which kept, going back and forth on this subject. So the Madison thing is not a problem. And of course, even if Madison did say something that was wrong, you just say the thing was wrong. I mean, apparently we can dismiss Thomas Jefferson with a wave of the hand.
Because he doesn't count. It doesn't matter.
And our friend Kevin Gutzman wrote a very important article in the Journal of the Early Republic saying that this attempt to minimize what Madison had been saying in 1798 about the rights of the states is unconvincing, that Jefferson was the radical, but Madison was the careful moderate. No, I mean, interposing to prevent the enforcement of an act is not really substantially different from nullifying the act. I mean, this is ridiculous nitpicking. And not to mention, Madison later on was so eager to separate himself from all this that he flat out lied. He told people that Jefferson never used the word nullification in his draft of the Kentucky resolutions of 1798.
It was before November 10th or so. He had included that every state has a natural right to nullify all assumptions of authority by others within their limits. And without this right, they would be under the dominion absolute and something like that of whoever exercises that right for them. This was edited out during the process as they passed this. But according to Jefferson, it did not change the meaning. They just wanted to tone down the language because he still said at the beginning, any act outside the Constitution is unauthoritative, void, and of no force.
Yes, exactly right. Exactly right. Well, thankfully, they were able to dig up an original copy of the original Kentucky resolutions in Jefferson's handwriting with the word nullification in there. And so Madison had to back off. So, I mean, this guy is not reliable on this stuff. So to say, well, we have to take his word in 1830. Do we really? He's not particularly sound or reliable on this. Now, what about this claim? There's also a claim that nullification has, let me say one more thing.
I got a little something on this Madison thing too, if you got a moment.
You go ahead.
So one thing that's really missed by almost everybody who cites Madison saying nullification by a single state will bring a destruction of the Union, it's going to be chaos, dogs and cats living together, mass hysteria. They always skip over the very first sentence of Notes on Nullification, which, depending where you find it, Mark in his article links to the National Archives, which only prints an abridged version. It doesn't include his statement at the end where he supports nullification as a natural right. Instead of the Liberty Fund version, which has the full paper linked as well. But the very first sentence, we have to understand the context. We could debate whether Madison flip-flopped or not, whether he was right in 1798 or wrong in 1834, 1835, but he starts with this. Although the legislature of Virginia at a late session declared unanimously that South Carolina was not supported in her doctrine of nullification by the resolutions of 1798, it appears that they are still appealed to for the same. And then he explains what he means, because you have to understand the context of what Madison is talking about. Otherwise, we're looking at apples to oranges. He says the doctrine of nullification, as pushed by South Carolina, he said, may be clearly understood as this, as laid down in a report of the Committee of House of Representatives in 1828. A single state has a right to arrest the execution of a law in the United States within its limits. The arrest is presumed to be right and valid, and is to remain in force unless 3/4 of the states in a convention shall otherwise decide. So Madison was specifically writing about this particular proposal, where a single state would issue a resolution or an ordinance saying this federal act is unconstitutional. And soon as a single state said that, according to this doctrine of 1828, that it would be presumed to be null and void until you had a convention of the states to overrule it. He's saying this is nuts. And so if Mark or anyone else who opposes nullification cites James Madison as saying these modern nullification efforts are bad, they have to first point us to someone who's doing what James Madison was talking about. And no one has even attempted such a structure since 1834. So it doesn't even exist. Why is he avoiding pointing that out? I don't know.
Hey, everybody, let's take a minute to thank our sponsor, Persist SEO. If you are getting buried by your competition online, then build your brand, your reputation, and your lead flow with digital marketing by Persist SEO. If you are a small local business trying to compete against large companies in the service industry, then increase your visibility with Persist SEO. Or what if you have low or no leads coming in on a consistent basis? Well, then website search engine and conversion optimization can help move the needle to a more prosperous business model for you. Are you tired of cold calling and networking, meeting places getting shut down? Use your website as a lead generation engine. Or what if you're not showing up for your services in the search engines? Well, get found with Persist SEO's expert search engine optimization. All you have to do is call 770-580-3736 or visit them at ineedseo.help for a free website audit and consultation. That's 770-580-3736 or ineedseo.help. I don't want to assume everybody listening knows about the Virginia and Kentucky resolutions of 1798.
Right.
So this is a little bit obscure for a lot of people, but I'm so used to my listeners being familiar with it. But in 1798, Virginia and Kentucky passed resolutions in response to the Alien and Sedition Acts of that year that raised serious constitutional issues. And the Kentucky resolutions, our friend Marco Bassani says that the Kentucky resolutions are the best short summary of the Jeffersonian view of the Union, and which he explains that the states created the federal government, delegated certain powers to it, reserved the rest to themselves, and that if that creation of theirs should go beyond the powers granted to it, then the creators of that thing could then prevent it from doing that. I mean, the idea is that federal government is just your agent. The principles are the states. The agent doesn't tell the principals what its powers are. It has everything completely backwards.
Even John Jay agreed with that. He specifically said that the federal government would be merely their agent.
Yes. Okay. So there it is. Okay. Well, so the Virginia Kentucky resolutions were against that. So the story we get from Mark Pulliam about this is that none of the other states supported Virginia and Kentucky, and in fact, a bunch of them wrote resolutions against or statements against Virginia and Kentucky. So then I added this small detail that the reason that nearly all of those states opposed Virginia and Kentucky wasn't so much because they didn't like the constitutional theory of Virginia and Kentucky. It was because they liked the Alien and Sedition Acts.
Yeah.
They thought it was absolutely legitimate to put somebody in prison for criticizing the president. So those are the people you're siding with, Mark Pulliam. But more important than that is not 10 years later, these very same states in New England that had been the loudest about the blasphemy of Virginia and Kentucky, thinking that they could refuse to enforce an unconstitutional law. Forget that. Well, not 10 years later, the New England states were speaking in the same language. And they were not just saying the states have the right to issue feckless protests against unconstitutional laws. I've got the documentation in my book, Nullification. They are using language that, as I said in the article, would be offensive to the delicate ears of Mark Pulliam, because they are actively saying that the states would resist unconstitutional federal laws. I mean, Daniel Webster was making clear in 1812 that if the federal government resorted to military conscription, Massachusetts would block that. Like, that would not happen because Massachusetts would block that. Not because Massachusetts would hold a sign saying, hey, this is unconstitutional. Massachusetts would block it. And you hear the governor of Connecticut speaking this way. It's all over early American history.
Webster even said this is one of the reasons state legislatures even exist. Was to interpose between the federal government and them trying to use the militia for an unconstitutional act. And a number of states in the Northeast actually refused to, what they called Mr. Madison's War, allow the militia to be called up for federal service. Someone even, some bright person, I forget what paper it was, actually published James Madison's Federalist 46 as kind of an embarrassment to the president during this situation, where he advised in Federalist 46 that the people use a disobedience and the states use a refusal to cooperate with officers of the Union as a way to defeat federal programs, whether they were seen as warrantable, what Madison called constitutional, or unwarrantable, unconstitutional. So they kind of embarrassed him on that front as well in New England.
One of the things I know you want to talk about was the argument that nullification has never worked. If you go through U.S. history, it's never worked. Now let's leave aside the modern examples that you personally have been involved with, and go back. Why was that particular claim, I don't want to say offensive to you, but why did it get your attention?
Well, I think it really does get down to the definition, because if we go back to historical examples as well, we see people in Jefferson's second term refusing to participate in enforcing his embargo, whether in New Orleans or in the Carolinas. He and Albert Gallatin were talking about, we can't enforce this thing. Of course, the response by the New England states to refuse to release their militia, even though James Madison had them called up for a war with the British in 1812. I think Murray Rothbard's treatment of the whiskey tax is absolutely incredible, where he discusses, and I can't remember the name, I think it was called the Resistance to the Whiskey Tax, a Model for Our Times. We're supposed to think that the federal government just came in and crushed the resistance. It was just in Western Pennsylvania, but he pointed out that they couldn't enforce the whiskey tax all throughout the back country. It was resistance and noncompliance by individuals, localities, even states, saying they weren't going to participate, and it ended up bringing it to an end. So if Mark is really, really focused on only saying nullification exists only as South Carolina had defined it in 1828, or how he defines it, a state says this is null and void, and therefore it's null and void. Well, no one ever really tries it, but they certainly do all kinds of other things. Thomas Jefferson, the day after those Kentucky resolutions passed, so November 17th, 1798, he fired off a letter to his friend James Madison. He said, here's a draft of the Kentucky resolves. I think we should affirm all the important principles they contain so we can hold to that ground in the future, but we should still be free to do what we need to do and not push as far as events will render prudent. Jefferson didn't give us a step-by-step method of how to nullify. He just pointed out the principle that when the federal government usurps power, it is the duty of the people and the states to take a stand to bring those acts to an end, even if it's only in their own state.
I mentioned something that I remember hearing Clyde Wilson say to me, and he was the editor of the Calhoun Papers. He was our friend Brian McClanahan's PhD dissertation advisor at the University of South Carolina. And his view was that in the case of the nullification crisis of 1832 to 33 over the protective tariff, it got heated. It's true.
Yes.
But what wound up happening was South Carolina said they were going to nullify the tariff, and Andrew Jackson said he was going to enforce it. But what ended up happening was they reached a compromise, and then, tensions eased, and that was the end of it. And so what Clyde was in effect saying was, we're so used to the version of history in the textbook that tuts us for having the wrong thoughts, that we can't see what's right in front of our faces, which is that nullification in that case worked exactly as intended.
Yeah.
People got together. They said, all right, we're going to have to figure something out that satisfies everybody, and they did that. And that was what wound up happening. And I think in
South Carolina also nullified the Force Act. I think that's kind of a funny it didn't have any effect, but they passed another ordinance saying, well, we're nullifying what Jackson said he's going to use force to stop us.
I love that they nullified the Force Act. Like, the thing's all over, but they still go ahead and nullify the Force Act.
It was just another jab to say, you know what, we're holding to this principle anyway.
Yes, absolutely. Absolutely. We reached a compromise, but we still have the power to do this. I think the very fact that there was let's say in the early republic, there was enough of public opinion that believed in what were called the principles of 98, that the states had this power in the last resort, that it could well have prevented the federal government from taking certain liberties that it might otherwise have tried to take. Again, Daniel Webster against the possibility of military conscription would be an example, but we see our nullification language being used to argue against unconstitutional searches and seizures. It's quite a few different issues over time that it was used. Of course, it was used on behalf of the right to the freedom of speech under the Alien and Sedition Acts. So just knowing that the states have a defense mechanism just even that, sometimes, in other words, they might not even have to exercise it. Just the knowledge that they have it can help to keep the feds in check a bit. And so it can work in that way too. It can work by having crises not occur in the first place.
Well, we're always under a crisis when we live under the largest government in history, because unless people actually take a stand, as long as you rely on the government to limit its own power, if you wait for the government to do the right thing, which it never does, we shouldn't be surprised that government keeps growing and growing and growing, no matter which team is in charge, no matter who sits on the Supreme Court. And that's why Jefferson, that's why Madison, and that's why so many of the old revolutionaries, going back to the American Revolution, whether it's Patrick Henry said, when they try to pass a tax, an internal tax, you are not bound to obey them. This is the mentality that created the American Revolution. This is the beginning of the principles that they tried to instill under the Constitution as well.
All right, Michael Boldin, I'm going to give you the final word. And if you're done talking about this Mark Pulliam article, you are welcome to say a word on behalf of the 10th Amendment Center.
Well, what I would love for people to check out is our annual State of the Nullification Movement report. Mike Meharry and I are going to be updating this for the year 2024, probably into the early fall, but you get a lot of information on what's been going down, examples of how we use the broad definition of nullification, which is any act or set of acts by individuals, localities, and states, which has as its result a federal act being null and void in practice or in effect. And that's really the most important thing, because as long as they keep passing stuff, if they can't enforce it, they can keep putting stuff on the books all they want. I mean, of course, we want to get rid of that stuff in the long run as well, but at least in the short term, the way we advance liberty is by doing what we believe is right, whether the federal government happens to agree or not. That's over at 10thamendmentcenter.com/report. It's like a 150-page free download that goes through the entire history of all this stuff, going back through the American Revolution, and as what Murray Rothbard once called the people's nullification of the Stamp Act, and applying those same strategies on various things today. So, like, for example, today, August 1st, 2024, Louisiana just became the 5th state to treat gold and silver as money. The government, of course, the government people want us to use their dirty fiat trash, whether it's paper or physical. But we have a number of states that are starting to create a market and an environment that runs counter to that. And it works when the people actually have an option to choose something else. And that's why I think this type of effort is so important. And it's actually very effective. We can see a lot of things happening on sound money and rejecting a central bank digital currency in Utah as well. But you can get all those details in our annual report, 10thamendmentcenter.com/report.
And of course, you all know that I couldn't endorse 10th Amendment Center more highly, and that I support the 10th Amendment Center, with what somebody of my means, let's say, would consider to be a reasonable donation. I mean, it's not a Rockefeller-sized donation is my point. But
someone of my means thinks it's a Rockefeller-sized donation every month for years, and I'm so incredibly grateful because it's been very helpful, very, very helpful.
Well, I'm glad to do that, and I say that because I want people to know, that if you support the 10th Amendment Center, you're supporting something you can rely on. Michael Boldin's not driving around in a chauffeured limousine or any other kind of limousine. The money goes to good purposes, and he gets results, and he's not bombastic. He's you can get a lot of that, but that's from a lot of people, a lot of content creators. But the question is, what are they actually accomplishing? He accomplishes a lot, which is why I've been supporting him for so long. And as you say, like I'm happy with how much I give. I just wish it could be more. I wish I were a Rockefeller.
Well,
but
grateful.
All the same, I've
very
never
grateful.
ever doubted my decision to support the 10th Amendment Center. So do check out 10thamendmentcenter.com, because I know there are some of you out there of means who are saying, because you write to me and you ask me, what are trustworthy organizations where I wouldn't just be throwing my money out the window? 10th Amendment Center, definitely on that list. So check them out. I have the link in the description and at tomwoods.com/2525. Michael, it has been, this is my first time having you on in the video age of the Tom Woods Show.
I hope my hair looked good.
I beg your pardon?
I hope I look good. I did my hair.
Oh, you look tremendous.
Oh,
You look
that's great. So
do you.
Of
course you look super young because you you are 4 months behind me. Let's all remember that.
I mean, I'm barely a baby at this point. Edward Snowden's attorney, Ben Weisner, one of his attorneys, a few years ago, Mike Meharry and I were out in New York City meeting at ACLU headquarters, and they were making fun of us for being opposed to Obamacare and gun control, but they wanted to work with us on these state-level efforts to push back against the surveillance state. And Ben Weisner was his name. He said, oh man, you guys are really punching above your weight class. And I think that's something I really take pride in, is that we do, like you're saying, Tom, we're not wasting the loot on, fancy stuff over here. We're really, really making every piece of that quickly depreciating, dirty government fiat go to value, take a stand for the Constitution and liberty, whether the government wants us to or not. So thank you so much for your support, Tom. I really, really appreciate it.
And I'll let you all know that there have been times, and maybe I shouldn't say this, but there have been times when, I think these are in the past, but when I've been legitimately concerned for my friend Michael Boldin, that he's overworking, and that he's really, really pouring too much energy into this. You don't get that from the big think tanks. You don't worry that the president of the so-and-so foundation is working too hard. That is not your concern.
I'm definitely working too hard, but I do love what I do, and I'm really, really blessed to be able to do what I love for a living.
Yeah, I know. It's an extraordinary thing. Well, thanks once again, Michael, and thank you, ladies and gentlemen.
Make yourself and those you love less vulnerable to the regime, both mentally and physically. Get more forbidden information at tomsfreebooks.com, and be sure to subscribe to the show wherever you listen. See you next time.
Like the sound of The Tom Woods Show? My audio production is provided by Podsworth Media. Check them out at podsworth.com.